Hi, Wes Scott from Kane and Scott. Today we're going to talk about the most common objection to a debt being discharged in Chapter 7 bankruptcy. You know, the whole goal of a Chapter 7 bankruptcy is to get a discharge. And a discharge means, of course, your liability on the underlying debt is wiped out tax-free forever. There are reasons why creditors, limited reasons, why creditors can object to you discharging a debt in bankruptcy. And of course, not everybody can do it because if they could, they would, and it would defeat the purpose of filing bankruptcy, right? So there are limited reasons set out in Section 523 of the Bankruptcy Code, giving creditors reasons to object to you discharging a particular debt. The most common objection we see, and it happens very rarely, is under Section 523A4 of the Bankruptcy Code, and that is creditors objecting to you discharging a debt for fraud. Now, there are statutory presumptions of fraud, so that if you've taken money out in a certain time frame, cash advances or purchases, there's a presumption that it's fraudulent, and the debtor, you, has to overcome that burden of the presumption of fraud. If it's outside those periods, then the creditor has the burden of proving you committed a fraud. This is extremely rare that this happens. It does happen. Usually we get warning letters from the creditor saying, look, this stinks. We usually write them back saying, look, here's why it doesn't. And I think the vast majority of times an explanation is satisfactory. And sometimes they proceed with objecting to you discharging part of the debt with them based on fraud. And most of those get resolved before any bankruptcy judge is involved. Very few of these things get tried. When the time is right, when you are ready, reach out to Kane and Scott. You'll be so thankful you did. Have a good day.